Good morning. This is the Judiciary Committee, non-civil of the State House of Representatives. We're here this morning to consider Senate Bill 13 by Chairman Smith, Chairman of the Judiciary Committee of the State Senate. Before we begin, let me just let folks know there's the clipboards over here by Ms. Travis in case anyone wants to sign up to testify. Let me ask everyone in the audience, if you would. These things are great. How do we live without them? But please put on silent or vibrate if you would. They can be very distracting when they all go off at once, which they tend to do in meetings. With that, let me welcome Chairman Smith to come forward if you'd like, and welcome. Absolutely. What I'd ask you to do, Mr. Chairman, is if you would certainly feel free to make any opening statement that you'd like to make, and then perhaps after that we could just go through it. It's not a terribly long bill, so which is always a good thing. So I wonder if we might be able to just, after your statement, just go through it section by section. Given the fact that it's a comparatively brief bill, I don't think we have to do questioning on a section by section basis. We can probably hold it for after you go through. We can do our due diligence on that, and then open up to members to ask you questions, and then after that we've completed that, then we'll get to other witnesses. My sense today is that we'll go until about 11:45 noon. If necessary, and it probably will be necessary, we'll probably continue with the intent of wrapping it up on Wednesday morning. Our usual times are Monday and Wednesday, and for committee members just in general, given the fact that we're going to be in recesses now on Mondays and Fridays, my sense is that our Monday meeting will be at this time as opposed to 8:30, allow people to get in and not have to fight as much of the traffic war. That certainly will allow our Vice Chairman, Mr. Hatfield, from Waycross, to provide him some more time as well. And so I think on Wednesday we'll probably end up coming to closure on this if I had to throw the dice on that. So with that, the floor is yours, and thank you so much for being here.
Well, thank you very much, Mr. Chairman, and thank you to the members of the committee. That you intend to seek the death penalty against him or her, to believe in good faith that aggravating circumstances exist in the statutes that would qualify the case as a capital case, to pursue a conviction on the death penalty, and then to either reach a plea bargain or a failure to obtain a death penalty recommendation from a jury and back your way into a life without parole sentence. There are all kinds of crimes that get committed in Georgia, and even within the context of murder, there are different circumstances that arise. Some of those circumstances do not, under our code, allow for the imposition of the death penalty. They don't qualify with those aggravating circumstances. In some cases, the victim's family urges the state not to pursue the death penalty. In some cases, the state, for various reasons, cannot or believes that it cannot obtain the death penalty in a case, even one that qualifies, whether because of the jury, the place where the crime committed, the nature of the victims or the perpetrator, or the circumstances surrounding the crime. And yet, many people believe that in some of these cases that the convicted murderer should not be back on the streets, even with the relatively long period of time we have prior to becoming eligible for parole under our amended statutes from a couple of years ago. So at its heart, what this bill does is seek to allow prosecutors to seek a life without parole sentence for the crime of murder at the front end without making the case a capital death penalty case. So you'll see in 1651 an amendment to the law which allows for a sentencing range to include life imprisonment for life without parole, along with death and life with parole. Under the previous setup, as I mentioned, the way you typically would route towards a life without parole sentence was to go towards the death penalty statutes, seek the death penalty, and essentially either fail to get that or reach an agreement about life without parole. And so there were a series of statutes you'll find in 1710-30, 1710-31, and what they did was add the life without parole statute following those statutes. So they would be the 1710-30.1 and the 1731.1. And the .1 statutes are the ones that followed the death penalty code that allowed for the imposition of life without parole in those capital cases. So what we have done is include a life without parole sentencing option where the crime of murder is defined in 1651. Then we have repealed those sections, the .1 sections, which articulated the route to life without parole under the previous scheme of the capital cases, and those would be the 1710-30.1 and 1710-31.1 statutes. We clarified on page 2 in 1710-2 the references to defendant are changed to accused. It's just that's really not so specific to this bill. It's just a series of cleanups that we've been doing in this committee and in the Senate side as well. Anytime we open up these code sections, we typically are changing over those references from defendant to accused, which is a more precise term in the code. And then we added, you'll see in Section 5 of the bill, and I know we'll come back and certainly I'll be happy to take questions. We added a clarification in working with the various stakeholders that deal with this issue, from the prosecutors to the criminal defense attorneys, including the capital defense attorneys, talking to the judges and others. We felt like that one of the issues that arose was the potential for a jury to be somewhat confused about what sentence they were recommending, or in failing to give a death penalty sentence, what sentence would be available to the court. And in some cases, there was testimony within the last couple of years that juries were that people were concerned that juries felt like they may need to give a death penalty sentence because they weren't sure what a life sentence meant, because there are two types of life sentences in Georgia that can be given. So during the metamorphosis of this bill over the last couple of years, we reached an agreement with the various stakeholders about a very clear jury instruction to be given, and that's outlined on lines 113 through 123 of page 4 on the version that I have, LC 293571. That explains life without parole means the person is incarcerated for the remainder of his or her natural life and is not eligible for parole. And life imprisonment, and it explains what that means they are incarcerated for the remainder of their natural life, but they are eligible for parole at a certain period, and that's defined elsewhere in the code. We did create an effective date on the code that would contemplate the new law going into effect. We've changed that. That's the only change we've made since the bill passed out of House Judiciary Committee last year. We changed and updated the code effective dates to 2009. And the way we did that was we said that if you committed a crime prior to July 1, 2009, that you would be under the previous, or in this case existing, statutory scheme, unless you, by writing, elected to fall under the new statutory scheme that we assume and hope and believe will go into effect in July of this year. And so that's the way we've structured the effective date. It is structured to become effective on July 1st, 2009. I'm certainly open to changes in that area. We have recently been considering the impact of the potential of our session running into the month of June, which would be a new thing for us. In which case, if the governor uses his full amount of time to consider bills, he would have beyond July 1st, 2009 to sign a bill into law, and the effective date would then bump to January 1st of 2009. That's a little bit problematic on this bill because we've created something of a split effective date by saying that crimes committed before July 1, 2009 are treated one way and those committed after are treated another way, unlike a typical bill that might just say the effective date is July 1, 2009. We can work on that and change that. I don't anticipate that this will be a difficult bill for the governor to sign or that he will need a long period of time, and I don't anticipate that we'll be in session in June, but I know that that's an unforeseeable event at this time. So we could certainly make it upon the governor's signature or 1 month after the governor's signature. That would keep the bill from bumping the effective date to January 1st if the governor signs it after July 1st. It would not, however, necessarily change Section 8, which is the way that the bill treats those who commit crimes prior to July 1st. You may, in the committee's wisdom, elect to treat that as those who commit crimes prior to the effective date, and then change the effective date to upon the governor's signature. I will tell you that the Senate Judiciary Committee has twice heard this bill and twice passed it out unanimously. The Senate, on 3 different occasions, has heard a version of this bill, and on 2 of those 3 occasions have passed it out unanimously. On the other occasion, it was a vote based upon an addition that the House made in the Rules Committee, and so the vote was somewhat split on that. And in the House Judiciary Committee last year, this bill was considered and had received a unanimous vote as well. And other than the effective date changes, I have not made any changes to the bill since the House Judiciary Committee voted on this bill last year. So that's the overall summary of what the bill does, and I certainly, Mr. Chairman, would be happy to answer any questions that the committee may have.
Mr. Hatfield.
Thank you, Mr. Chairman.
No.
Yeah. No.
Yes. No.
Okay. Senator, just a couple of things. I noticed where the language was changed from defendant to accused. We're talking about at a point in the process where the defendant has actually been convicted at that point or has been found guilty, and you're considering actually the appropriate sentence. I was just wondering, would defendant really not be the more appropriate term at that point than accused?
Well, the reason why we chose accused, and I certainly would defer to the opinion of the Legislative Counsel's office, but accused is a broader term that would apply at all stages during this process, from the time that indictment is drawn up or some accusation or arrest is made until the accused receives his or her sentence. And so I believe we felt like that term would more precisely cover the full range that the bill could relate to, rather than defendant, which has a more specific meaning.
Yeah. Ms. Travis, do you know, is there some definitional component to that would make that really the more appropriate term?
We actually started looking at this term as we did the evidence code, and that's what kind of brought to our attention, because so much of the evidence code is applicable both in civil and criminal proceedings. So I think it was Chairman Smith that actually said, why don't we use accused so that we're clear where this is a criminal case that we're applying it to, as opposed to defendant that could be a civil or criminal case. And we looked up the definition in Blacks, and it is a much better term for any criminal case because they are always the accused, and that's why we made the switch over in this bill.
Okay. Thank you. One other question, Senator, is going over to page 4, beginning line 121, that's subsection C, and that provides if the jury is unable to reach a unanimous verdict as to sentence, the judge shall dismiss the jury and shall impose a sentence of either life imprisonment or imprisonment for life without parole. Basically, if the jury is not able to reach a decision, then the judge will have the sole discretion in whether or not to impose life without parole. Is that correct?
Well, that's right. This is in a capital case. I believe this is 171031, which is in the process where a death penalty trial would be receiving the sentence. And that is the current state of the law. And so what we did was we made sure to anything that we repealed in 171031.1 or 30.1, we made sure that language was incorporated within the rest of the bill. And current law is that when the jury fails to reach a unanimous verdict, then the court would then dismiss the jury and impose a sentence, and the options of the court would be life or life without parole. So that is not a change to the current state of the law, but it does reincorporate into 171031.
Okay.
And I'll tell you, I failed to mention this, but I think most of you are somewhat familiar with this bill. It is widely supported by the prosecutors across the state and is probably their number one agenda item that they would like to see accomplished legislatively this year. Interestingly, the bill is also widely supported by many criminal defense attorneys across the state. In fairness to them, they are somewhat split over this bill because some of them feel like it has the potential for prosecutors to step up a case from one that would have been appropriately sentenced to life with parole to one that now could be eligible for life without parole when it otherwise would not have, in good faith, been a death penalty qualified case. But many of the criminal defense bar believe that this will be a better option for them at the front end that will also avoid many cases getting pushed into the capital category that otherwise would not appropriately be there. So it's probably the only thing I've worked on down here where there is general agreement between the prosecutors and defense attorneys that this is a good bill and a good idea to have incorporated into the law, with the caveat that some of the capital defense attorneys and some of the criminal defense attorneys believe it might be used as a negotiating hammer. But most of them that I've talked to think it is a good idea.
Just following up on that, Mr. Chairman, as to which direction the prosecutors will go, this bill, as I've studied it, to me is really about discretion. This is about, and I'd be interested in your comments on this, to me this bill is about giving the discretion to the prosecutors that we elect in our local circuits, the discretion that they need to make the proper decision at the time on a case-by-case basis as to what they pursue and why. My sense of it is the people elect them to do exactly that. This widens that discretion certainly to where it needs to be, wider than it is right now. And if they fail in that discretion, they're going to hear about it at the ballot box, and they should. But it seems to me we elect them to exercise that, and this is fulfilling that mandate that's given to them by the people. What are your feelings about that?
Well, Mr. Chairman, I would agree with you. Prosecutors are a unique breed of lawyer. I think they would agree with that as well. A number of them are here today that are available to testify to you. But unlike lawyers that represent civil clients, for example, who often seek to obtain the maximum result for their client in a pretty adversarial court system that we have designed, prosecutors represent the state and are really charged with seeking justice. Their job is not to seek the maximum penalty in every case. Their job is to review the facts, charge what they believe is the appropriate crime, and seek a fair penalty for that crime. The system doesn't always work, and no prosecutor is perfect. They often have different views on what is the appropriate sentence, but that is their job, is to have discretion and exercise that discretion. And then, of course, there's an interplay of that with the defense attorneys who seek to make sure the prosecutors prove their burden of proof, and then the court who ultimately renders that sentence, except in the one case of capital crimes where the jury makes a recommendation that is essentially binding on the court. The court has an opportunity to make sure that justice is done as well. So I think prosecutors have that charge and that duty to attempt to seek justice, not necessarily the maximum penalty. And there are cases where the facts do not warrant or even allow, under our current law, a death penalty prosecution, but that also do warrant a sentence of life without parole, a sentence where the murderer should not be released out on the streets ever, under any situation. And in those cases, prosecutors don't have an option right now, except to, with a wink towards the law, seek the death penalty when they really don't intend to and don't believe they can obtain the death penalty. Now, some of them may say they don't do that, and maybe very few do that. But some will acknowledge that there is pressure on them to do that because it is the only route right now that allows them to get what may be the just result, which is a sentence of life without parole. So at its heart, this case, or this piece of legislation, allows discretion for more sentencing options at the front end in non-capital murder cases.
Mr. Franklin.
Thank you, Mr. Chairman. I'm on page 3, looking at lines 76 to 80. If all you did was kept the strikeout on line 82, other than a sentence of life imprisonment or life without parole or death, how is this new language that you have on starting on line 76 different than what remains on 81 to 88?
I'm going to ask Ms. Travis to comment on this, but I believe we were reincorporating language from some of the other strike that we made to make sure that it was in the code section, and I'll ask for her opinion about that. it does not represent a change in the state of the law. I do not believe.
Because it looks to me that we're saying the same thing, just using a few different words. But I'm wondering, would it just be easier to not, since we've got that stricken through on line 82, do we really need lines 76 to 80?
I think we do. I don't exactly recall why we did it this way. I'd have to reconstruct my thought process, but I know very specifically this has been reviewed several times, and it was agreed on. I mean, the AG's office has looked at it, the prosecutors have looked at it, and I know we did it for a reason. I regret that my memory banks aren't firing as fast as they were when I wrote this bill, I think 2 years ago.
All right, and if I could ask
Well,
one more question.
We'll track that down in the
Okay.
interim between now and Wednesday.
I appreciate that. And one final question, if I may, and that's on page 5, the section 10. Since this is not codified language, if Judge Boggs has a capital case in his court, would he be bound by this since it's not in the code?
I will also ask for comment from Legislative Counsel, but I will tell you that in working through the details of this bill and trying very, very delicately to seek the opinions of both sides or all sides of the stakeholders in this, this was language that was agreed to that the prosecutors initially asked to be placed here in the bill, actually. And you're correct that it doesn't come into a specific code section in the bill. I'm of the opinion that Section 10 is unnecessary. It is a summary of what in one sentence, of what the rest of the bill already does specifically in the code sections. But it also, because it's somewhat redundant and summary, I don't think that it has any sort of impact, negative or positive, on the bill, and therefore doesn't hurt it in any way. I don't think that sentence is binding on a court, and it would not be incorporated into a code section. But all it does is essentially summarize what this bill is without placing that in that form into the code.
It struck me as a provision that it's sort of a safety net type provision, that when I read something like that in any bill, it's a matter of, well, if other sections have, for whatever reason, fail, that Section 10 is in there, so it's a just-in-case provision. But I don't know that it would like you said, I'm not sure it would have any binding effect.
Yeah, by passing it, I mean, you offer what amounts to legislative intent of what the purpose of this was, so that in the event that there is confusion, lack of clarity, or, as the chairman points out, a portion that's not upheld, it can be opened up and seen later as the purpose for this and what the intent was in passing the bill.
Thank you.
Actually, Chairman Smith does iterate exactly the purpose. It is completely redundant. If you read the code section itself, the code sections together, the intent is there. It is merely only a summary.
Ms. Benfield.
Thanks. We should have heard this last week for Groundhog Day. I think this is the third time I've heard the bill, and I appreciate you bringing it up again. My main concern is, as most of us know, what happened to the bill in the past is that it's gotten bogged down with amendments, most specifically the non-unanimous jury verdict and sentencing phase of death penalty cases. And you've been great about just wanting your bill to pass clean, and I just want to hear from you whether you continue with that commitment that you want this bill to pass without that amendment tacked onto it.
Well, I appreciate that question, and I very much appreciate multiple considerations by this committee, the House and Senate bodies, over a 3-year period. I'm a little dogged in my determination to pass this, and I hope you appreciate that as well. If the world were perfect in my limited view, this bill would pass out with no changes, and I would not have to deal with the potential of a conference committee or amendments placed on the floor in the Senate. However, that being said, I have a tremendous amount of respect for this committee on the House side and its counterpart on the Senate side. And I know that you all do a very diligent job in reviewing and making changes to the bill, and I certainly will accommodate that input and those changes. To the extent that we can keep it from being amended into something that it is not, that would be my goal. And I hope that we wouldn't have amendments placed on the bill that would cause it to fail either on the House or the Senate side, because this is a very important bill that will save a great deal of money and allow for what I believe will be a tremendous improvement in our murder prosecutions and defenses, frankly. So I would urge the committee to hold true to the original intent of what this bill does and not turn into something that it is not. I have spoken to some members of the House leadership who believe that this year the bill can pass out in its form, and I hope that that is certainly true. I would certainly love to see the bill structured as it comes out of the Rules Committee in the House, so that it doesn't become a Christmas tree for other amendments on the House floor. I think I have a pretty good commitment on the Senate side that will not happen. And so even if it gets amended in House Committee or in Rules and comes back to the Senate, as long as it's in this basic form, I believe that we will not have trouble passing the bill into law. If it turns into something different, then it will probably fail once again.
Thank you. Can I ask just a quick follow-up? I think my recollection is correct. Under current law, if you get life without parole if you get life for murder, you're eligible for parole in 21 years. Is that right? Is that the current? No.
We changed it to 30.
It's 30. It was 21.
It was 14.
14. I remember that, and then I thought I went to 21. It's 30 now?
When the sex offender bill came through a few years ago, I think I pointed out that you had a longer sentence for the sex offense than you would if you killed someone, and which was true. You were not eligible for parole until 25 years had passed if you committed a sex crime. If you went ahead and murdered the person, then you could get out in 14. So everything else being a lesser included crime. So the response to that was to change the parole date for murder to 30 years, and that's what the will of the legislature was at that time.
One last question. What are the other crimes where, under current law, life without parole is an option?
Under what?
Under current law, what crimes is life without parole an option?
There's some, and maybe the prosecutor
the seven deadlies?
Can give this. You have, for example, I know rape listed as one, although there's been cases that have evaluated whether life without parole is an appropriate sentence in non-capital cases. Rape actually lists death as a potential sentence for the crime of rape, and Georgia has sentenced people to death for the crime of rape. However, the United States Supreme Court has reviewed that and essentially said that there needs to be a homicide. I hope I'm not oversimplifying this decision, but in order to impose the death penalty and make it a capital crime. But that's true. You can actually, the 7 deadly sins, you can become a repeat offender and end up with life also. They are much more qualified than I am to give you the list of crimes.
We'll hear from the prosecutors. We can go ahead and tie that up when they come forward. Mr. McDade comes on up. Mr. Setzler.
Thank you, Mr. Chairman. And I know we've been through this, so I apologize if this is ground we've covered already. As I'm reading lines 104 through 112, trying to get my mind around the conditions that have to exist for this life without parole to apply. Does it apply? Does it require? Really, two questions. Does this require an aggravating circumstance? And I sense that it doesn't, but I want you to confirm that. And secondly, is this a sentence that a prosecutor has to specifically ask for, or if it's a garden variety death sentence case or murder case where death is not being sought? Is this something that perhaps the prosecution could expect a standard death sentence with possibility for parole, that the jury could decide the facts warranted life without the possibility for parole?
Very good questions, and it is somewhat confusing because we're dealing with really non-capital and capital crimes, and so we're having to deal with both within this bill, and that's why it gets a little wrapped up together. I want to answer your second question first, and that is, it does not require an aggravating circumstance or a statutory death penalty case in order to receive life without parole. So in what you refer to as a garden variety murder case, without statutory aggravating circumstances, a prosecutor could seek a life sentence or a life without parole sentence. If the prosecutor chose to seek the death penalty and believed those aggravating circumstances existed, then that would trigger him or her to notify the defendant, go through that constitutional process that is in place, and that brings you into 171031, which is your first question. And that process, when you get to 171031, you're at the sentencing phase. The jury has heard the evidence, has found the person guilty of murder. They're reviewing whether or not aggravating circumstances exist. And what they are allowed to do here is they are allowed to make a recommendation of death, life, or life without parole. And that's what lines 104 through 107 say, is where you don't find aggravating circumstances, or where the jury finds them but believes death is not appropriate or does not recommend that by unanimous verdict, then the jury decides whether to recommend a sentence of life imprisonment without parole or life with parole, and they make that recommendation. Now, in an ordinary garden variety murder case that is not a death penalty case, the facts are tried, the guilt or innocence phase is decided, and once a jury unanimously decides guilty, then the court can impose either life or life without parole. And that's no different than any other crime that the prosecutor works through, and then the court renders a sentence after the guilty verdict is imposed, if it is imposed.
Okay, so structurally, Section 5 here deals only with those cases that exist within the subset of cases in which the death penalty is sought. Is that
capital crimes? That's correct.
Okay.
That's correct.
But those aside, just want to get back to cases that are not, quote, capital crimes. The sentence of life without parole does not require an aggravating circumstance. Is that correct?
Correct.
And there could be a case where the prosecution would anticipate a finding based on the facts, would anticipate a finding of life with parole, but the jury could decide really on their own to impose life without parole. Is that the case?
In a non-capital case?
In a non-capital case, does the prosecutor have to specifically seek life without parole, or is it open to the jury?
Well, and now I'll ask for an opinion, but I believe in a non-capital case, the court would impose the sentence, not the jury. The jury only renders a recommendation for a sentence in a capital case. And in a capital case under this structure, the jury can recommend life without parole, or death to the court. If the jury recommends death, the court must really impose the death. It's called a recommendation, but really the court must impose the death penalty.
Sure.
But in a standard non-capital felony murder case, you would have a prosecution for murder. You would have a guilt or innocence decision by a jury, and then the court would step in and render a sentence. And the jury does not have an option relating to the sentence. I'll subject to someone over deciding that's not true. There's a lot more experts behind.
I was just wanting to confirm this is not another level above a standard death penalty. This is not another level above a standard felony murder trial where the prosecution had to specifically ask for the possibility of life without parole. That's not required.
Correct. You really still got two types of cases. You've got
types.
non-capital cases, which now life without parole can be sought, and the court renders that decision. Then you've got capital cases where the jury makes a recommendation, and that's not dissimilar from the situation that we have now on the capital side, except we have some clarity built into it.
Mr. Levitas.
Thank you. I've never been confused for Kevin before.
Sorry,
but
Mr. Bearden.
hope I never will be again either. But
Can we go with Levitas? Is that
Please
Well,
don't get it started.
Yeah.
Just trying to keep the wheels
I like
on
door
the
number
track.
one.
It's been moving so smoothly until now. I'm sorry, but well, I'll put some minds at ease. I'm not planning on amending this bill because a lot of eyes went upon me when that question was asked by my friend in the cab. But while I do believe the death penalty has a very important role in the criminal justice system in this state, I just want to know what you believe will be the effect on the death penalty in Georgia if this bill passes, because I do not want to see a phasing out or a first step into phasing out the death penalty in this state. So what do you believe will be the effect on the death penalty if this bill passes?
Well, for cases that are appropriately prosecuted as capital cases, I think the effect is none. I think there will be no effect on cases in which prosecutors believe aggravating circumstances exist and that the death penalty ought to be sought. So I do not believe you will have any diminution of cases that are appropriately death penalty cases that will continue to be brought in the state. I do think that you will have, in a sense, a death penalty process that works a little better for those cases, because you will clean out cases which are not appropriately in that category but have been pushed into that category because it was the only way to obtain an appropriate sentence of life without parole. So in many ways, I think the death penalty process will work better in Georgia because you will have cases, only those cases that are appropriately qualified as death penalty cases in which it is that penalty is sought.
Thanks.
Mr. Mangum.
Mr. Chairman, I am going to waive until I hear some other I think some of the questions that I had were answered, and some I probably want to hear some other sides before getting in the. I'm trying to recall this. I've had so many bills that were in this area, and I'm not remembering this bill totally. But thank you for bringing this bill, and I look forward to hearing more. Thank you.
Thank you.
Ms. Travis had a breakthrough.
So that's why we added the new paragraph of 3 for the sentence of life without parole. You couldn't just restore the language on to 82 and 83. That wouldn't make sense. If you read all of those paragraphs together, that's why it was added.
Any further questions for the author? Mr. Chairman, thank you.
Thank you, Mr.
Good
Chairman.
conversation.
Members of the committee. Be happy to come back anytime.
We appreciate that. Thank
Almost
you.
anytime.
Would you swear in to make him say that again?
I wouldn't dare. David McDade with the DA's Association, please. Welcome.
Good morning, Mr. Chairman, and good morning to the members of the committee. My name is David McDade. I'm the District Attorney in Douglas County, Georgia. I'm here on behalf of the District Attorneys Association of Georgia. I first want to thank Chairman Preston Smith for bringing the bill and his dogged determination to see this process through. I want to thank this committee for its consideration of the bill. I believe this is the third time this bill, or the gist of this bill, has been before this committee. On behalf of the District Attorney Association of Georgia, I want this committee to understand this is and has been our #1 legislative priority for 3 years. This is our #1 issue this year, and we would ask for your favorable consideration of the bill. In support of this bill today with me are a number of prosecutors who fill up this corner pretty much, or people associated with prosecutors. Even Miss Sandy Michael has shifted over to our side of the table. Need I say more? In all seriousness, this bill is a bill that I look at as a victim's bill, and I want to tell you from my personal experience as a prosecutor what that means and how to understand what I'm saying. I've been a prosecutor for 28 years. I have personally litigated literally hundreds of homicide cases in my career. Without any doubt, the #1 issue that I deal with when I meet with victims' families who have lost a loved one to a horrible crime, is they want closure. They want a guarantee of finality in the sentence. So many times that's the predominant issue that family wants. They want to be assured that the person that took their loved one from them will never, ever, ever walk in society. That's the most important thing to most victims that I deal with. And under Georgia's current law, the only way in a murder case that can be achieved is to seek the death penalty and ask a jury to hear the evidence and render a verdict of either death or life without parole. In many, many cases that I've dealt with, and I have prosecuted a fair, considerable share of death penalty cases. In my particular jurisdiction, we have sought the death penalty a number of times. We have a very conservative jury pool in our community. In a number of those cases, the victim's predominant request is, Mr. McDade, do what it takes to guarantee that person never, ever hits the street again. And in those cases where I believe ethically that the aggravating circumstances exist, we seek the death penalty. I will tell you that I've never sought the death penalty, and I don't believe any prosecutor in the state of Georgia has ever sought the death penalty, where we were not morally and ethically convinced that the aggravating circumstances existed to support it. But I will tell you that there are a number of cases where, if the statutory framework existed to allow, as this bill does, us to reach a resolution of the case that ensures what the victims want, that being finality in the sentence, that justice will be served if we can resolve the case with life without parole. Now, to ask the question or to address the question I think my friend Representative Bearden asked, what will this do to the death penalty cases? I will look you all in the eye and tell you that in my particular circumstance, and I can only speak for myself, it will not sway me on a single case to not seek the death penalty where I believe it's the appropriate prosecution. Absolutely will not. What it will do, however, is allow me to sit down with victims in those cases that are in the, what I would call maybe the gray area, where if I took an aggressive posture on the facts, I could contend ethically that it could possibly be a death penalty case, but it's not the type of case that the appellate courts wholeheartedly embrace, nor is it what the victim's family want. And I can meet with the defense counsel, and I can give them that option. And most competent defense counsel then can make an informed decision as to whether or not they believe they want to go to trial or not go to trial on the issue of life or life without parole. In my particular circumstance, what I believe will happen is it will give judges greater discretion to decide amongst those cases where we're not seeking the death penalty, Representative Setzler, in that class of murder cases where we have not invoked the death penalty, but it'll give the judge the option to look at the facts in that type of case and decide, is this one that warrants the imposition of life without parole versus life with parole. What this bill does is it simply gives the sentencing authority, and that means the judge, in a non-death penalty case, the same discretion that that sentencing judge has in every other crime in Georgia. And every other crime in Georgia, except for murder, the judge is given a range of discretion, a range of sentencing options to consider in weighing out the factors and deciding whether or not the maximum is the appropriate punishment or something less than the maximum. In Georgia, because of our unique statutory framework, in a murder case where the death penalty isn't sought, the judge currently only has one option. A jury convicts, a defendant is found guilty of murder in a non-death penalty case. Under current law, the judge must sentence to the only available option of life with parole. And when I sit down with the victim's family and tell them that that is what the outcome is going to be, if everything turns out the way we expect it to in a non-death penalty case, the victims don't feel like they have justice in those cases. They ask me the exact question Representative Benfield asked. When will they get out? How many years is it? When I started prosecution, people were eligible for parole in 7 years, eligible for consideration. It increased to 14 years. Then the Department of Corrections offered statistics that said how long they kept them even after the first consideration. There's never been finality to it. There's never been a situation under Georgia law where I can sit down with the victim's family and say, under the law today, if this bill passes, under the law today, if this bill passes, I can tell you that life without parole means the person will never hit the street again. I ask you to support this bill. The District Attorneys Association of Georgia asks you to support this bill. And with all due respect to my dear friend, Representative Bearden, we concur in the sponsor of the bill's request that it travel in its infinite wisdom of this committee. We don't want any amendments either that deal with the substance of the bill. We too would appreciate any consideration this committee could give to allowing it to travel in substance without any amendments. Thank you,
Mr. McDade. What you're referring to is that the bill last year got caught up in another issue, specifically in non-unanimous jury verdicts. As I hear, of course, the author and I hear your testimony, it's my sense that you and the folks you represent in the prosecution community would not want to see that particular issue mixed in with the life without parole issue. Is that a fair statement?
That is correct, Mr. Chairman.
Okay, just want to make sure. Mr. Knox.
I'm sorry, I didn't mean to press.
That's all right. That's all right. No.
Just answer my question.
Mr. Mangum.
Well, I think I've been answered what I wanted to hear, except I do want to simply ask this. What are the first, on paragraph 3 that someone asked earlier, 76 through 80, what are those first convictions of a serious violent felony? What type of cases are those where a person would never see the light of day again?
Under serious violent felonies?
Yes, it says a first conviction of a serious violent felony, you would not be eligible for parole. What are those?
Well, that would be referring to the 7 deadly sins. Under the 7 deadly sin, that would be armed robbery, kidnapping, rape, aggravated child molestation, aggravated sodomy, aggravated sexual battery, and then murder would be the seventh.
Okay. So what are the circumstances? For example, let's take, you said armed robbery. If someone is convicted of an armed robbery, they tell me, I always give this proviso, I do not practice criminal law, so help me out on this. If your neighbor's son goes down, he's 18, which is not in the juvenile system, or 19, just make it, say he's 19, he's with your neighbor's son. He got picked up in the car with some really bad guys, and they were already planning to go rob this place, but they're his friends. He goes down there, he's in the car with them. He gets convicted of armed robbery with them because they meant to do it, and they did it. Would he, on a first conviction, would that mean that he would not be eligible for parole?
No, sir.
What are the circumstances where he would not be eligible for parole?
Let me try to answer it in a little bit broader context. This bill does not authorize life without parole for any conviction other than murder that doesn't already exist in the law. Everything else in this bill is a restructuring of the framework that Legislative Council has put together to make certain that when we refer to life without parole, we're not offending the provisions of the law that currently exist with life without parole. Under your scenario, the statutory framework that currently exists for an armed robbery defendant would be he would face a sentence of 10 to 20 or life. That would be the sentencing options available to the judge in that circumstance. The particular reference that you made is dealing with the semantics of the bill that require that it be restated to include murder now as one of the serious violent felonies that could get life without parole, but it would be the only one that could, the way the bill is drafted. This bill doesn't speak to the sentence for any other crime but murder. It doesn't raise the punishment in any way for any other crime but murder.
So what you're clarifying, Mr. Chairman, if I could, Mr. Mangum, just to make sure I've got clarity with your question, and the answer is that for purposes of the seven deadly sins, if I'm hearing you correctly, the life without parole alternative is still confined to murder as opposed to the other six. Is that a correct statement?
Under this bill, yes.
Yes. Is that?
I guess that's what I'm trying to get clear on. Thank you.
Okay. Ms. Benfield.
What happened earlier is when you called on Chairman Knox, it was my button that was lit.
I'll master the screen sometime
okay.
in March.
Just one question. In your presentation, Mr. McDade, you referred to Georgia's unique statutory framework. So my question is, are we the only state with only one option of life without parole where the death penalty is not sought? Are we the only state with this setup?
We have looked at every state in the union, and I'm like Ms. Travis, I don't recall the specific breakdown. I know we're in the vast minority of states. In my recollection, something tells me there's at least 26 other states that have multiple options for sentencing. That Georgia's in the minority of cases where we don't have a sentencing range available to the judges for murder outside the death penalty. Excuse me.
Can I ask one more follow-up? Is there a sentence less than life for murder cases? Can, like, 30 years be imposed?
In Georgia?
Yes.
No, ma'am.
So life is the
threshold.
I guess lowest.
It
Okay.
is.
Thank you.
Any further questions for Mr. McDade? Mr. McDade, thank you so much. Mr. Gerald Word.
Thank you, Mr. Chairman. I always feel uneasy when I agree with David McDade on something, even though he is my friend. But I currently am the Georgia Capitol Defender, and I just wanted to speak to how we feel this bill will specifically impact the Georgia Capitol Defender. And agree with Mr. McDade that there are a lot of gray areas, not a lot, but there are gray areas out there where prosecutors say to me, we're satisfied with something less than death, but the only way we could get to life without parole is to seek the death penalty. And I think this will, to answer Representative Bearden's question, more purify the death penalty, in that those cases that they're seeking the death penalty will be cases where prosecutors truly believe death is the appropriate punishment. From our standpoint, it will, if it has an impact on the Georgia capital defender, it will probably reduce the number of cases that we defend because of that impact. I think that the prosecutors will, in those gray areas where they are satisfied with life without parole, they will now have the option of merely going for life without parole without having to seek the death penalty first.
Mr. Ward, when you say the gray area, to me that equals back to the issue of discretion.
Right, correct. And exactly what Mr. McDade said, there are cases where statutory aggravating circumstances do exist, and they can ethically seek the death penalty. However, in the prosecutor's discretion and in maybe the family's mind, they're satisfied with a life without parole. They feel justice has been served with life without parole. And I know of some cases where prosecutors have said to me, we only sought the death penalty because we felt this called for something more than a straight life sentence. We felt like we had to get life without parole. And our hands were tied because we had to seek the death penalty to be able to accomplish that.
Mr. Hatfield.
Thank you, Mr. Chairman. Mr. Ward, and perhaps this question would be more appropriately directed to the public defenders, but do you think that the passage of this legislation would result in situations where people would be put under a sentence of life without parole, that maybe the punishment would be increased over that which probably would be warranted under the circumstances?
Representative Hatfield, to answer your question, and by the way, I am still technically the circuit defender for the Coweta circuit, so Mr. Bearden's circuit, okay. And Mr. Crawford asked me to address those issues for the circuit defenders too. What I think I don't think this changes the current state of the law specifically. The only impact I can really see is that I think circuit defenders will now have an obligation, because under the old system there was only one option, and that was life with parole. I think they will have to now seek out the mitigation and be a little more diligent in the presentation of the sentencing, because before, quite frankly, you knew they were going to get life or they were going to get life, so it really didn't matter. And so maybe you didn't put up those family members or that psychologist. So it might impact it slightly in that sense, and it might require a little more due diligence on behalf of the defenders, but I don't think it really substantially changes the law as it exists right now with respect to non-death murder cases.
So you think that it probably would not produce a significant number of cases where under current law the prosecutor looks at the case and says, well, this is a case that would just be a life imprisonment case, that it would not increase the number of those cases that now are seen as life without parole?
Well, I feel like it probably will do that in the sense that I think prosecutors will have more discretion, and they very likely will choose to exercise that discretion. I'm just not sure it impacts as far as how these cases are defended or handled. Like I said, I think the only impact is that the defense lawyers have to do a little more due diligence in giving the judge the information he needs to exercise his discretion in deciding what the appropriate sentence is. But I would truly expect the prosecutors to now feel a little more free to exercise that discretion that so far they've been kind of, had their hands tied to, and they've had to say, okay, I'm either going to seek death or this is a life with parole case.
Do you feel that there should be any other any trigger that brings about the qualification for life without parole, or do you think that it should be just left to the discretion of the prosecutor to ask for and the judge to impose?
I don't know that I have an opinion one way or the other. I mean, the other scheme would obviously be similar to a death penalty case. You would have to prove an aggravating circumstance, which is quite frankly not real hard to prove in most situations. and you certainly could have a jury have to decide that. I'm not advocating one way or the other, but that would be the other scheme, is that it has to be triggered by some statutory aggravator similar to in death penalty cases.
One other question is sort of follow up on what Representative Bearden was asking. Do you think that that the enactment of this legislation without any sort of statutory trigger for life without parole could lead to a situation where either the death penalty statute may be endangered because of the passage of this bill, or do you think that it could lead to a situation where appellate courts would start overturning a lot of the life without parole sentences?
And it's kind of a two-part question, I think, and I agree with Chairman Smith, Senator Smith, that I think as far as the death penalty is concerned, this will probably alleviate some criticism of the death penalty, in that I think that the cases that you see in the death penalty realm will be a little of a, I hate to use the word, but more pure variety. So from that standpoint, I totally agree with Chairman Smith on that. As far as the overturning, I think kind of the caution I've said before, if public defenders don't do their due diligence and present mitigation that the judge should hear, then there could be a problem. But I think that's something we've got to address with the defense bar, and that we've got to educate them and make sure that they've done their proper due diligence.
Okay. Thank you.
Any further questions for Mr. Word? Thank you, sir.
Thank you, Mr. Chairman.
Let me ask Mr. McDade if he could to come forward just for a 1 minute. The issue of aggravating circumstances, and just very briefly, Mr. McDade, for the edification of the committee and for any folks who might be watching. When we're talking about aggravating circumstances, what are we talking about? Can you outline that for?
Yes, sir. There in the statute, 171030 sets forth 10 aggravating circumstances that must exist and that we must prove beyond a reasonable doubt that they exist before death is a sentence that's eligible. If a defendant has a prior capital conviction, for instance, if it's the second time a person has committed a murder, and for the definition of capital crimes, that's a shifting definition in Georgia's framework, but just use that as an example. If he has a prior conviction for a capital crime, that's one aggravating circumstance. If he committed the crime during the commission of another particularly heinous type of crime under the statute, if he's committing the murder during a burglary, for instance, that can be an aggravating circumstance. If he or she commits the murder for hire, for pecuniary gain, if someone pays them to commit a murder, that's an aggravating circumstance. There are 10 set out in the statute, but those are the types of kinds of cases that we're talking about, the more aggravated types of cases. There's a phrase, 17, it's called B7 for death penalty prosecutors and defense attorneys. If the crime itself is just outrageously and wantonly vile, horrible, and inhuman, in that it involves torture or depravity of mind. If your victim is tortured and these other circumstances are found to exist to the jury's satisfaction beyond a reasonable doubt, that in and of itself can make the crime of murder one that's eligible for the death penalty. That would be an aggravating circumstance. Does that respond to the chairman?
It does, and I think it was important to get some clarity on that for the committee and just for anyone viewing the hearing that may have heard that term, that expression thrown around a little bit, just to give that some definition. Mr. Hatfield.
Thank you, Mr. Chairman. Mr. McDade, do you think that there should be any aggravating circumstance trigger associated with seeking life without parole, or you think it should just be basically just prosecutorial discretion?
It's actually judicial discretion at that point, to be quite honest with you, Representative Hatfield. What I think the prosecutor's role is to lay out all the evidence to a jury, and if the jury then convicts that person of that murder, then it's up to both parties at that point in time to attempt to persuade the judge, who is going to be then the fact finder, as to whether or not this falls into that category or doesn't fall into that category. But I want to ask you to step back even further from your question. We currently have a sentence that says life in prison. And to most people in Georgia, we've all come to know that doesn't really even mean life in prison. So the aggravating circumstance that I look for is, did the person commit the murder? That's an aggravating circumstance enough in my humble personal opinion. But to answer your question directly, no. The framework that's set up now, I think, is the appropriate one, the way this bill addresses it.
Well, and I agree with you. I mean, we've gotten kind of far afield from when you look at the actual terms. If it says life in prison, and you know, there a lot of people feel like that common sense would dictate that we would follow the common usage of the term, but there are degrees of murders. I mean, not specifically written into our code, but there are some that are obviously more serious and more heinous than others. And I wonder if, you know, in that regard, whether or not that if we believe that there are graduated levels, that maybe we should be looking at, you know, a situation where we could add, rather than just life with the possibility of parole, if we had a specific number of years or something that a judge would have the option of, and we could get to a more pure way of looking at the sentencing options. But basically, and I'm for this bill. I mean, I think that DAs and judges need that option. But I just wonder, do you think there'll be situations where prosecutors may be overzealous and convert what would just be an ordinary, and I don't mean to say that in a callous manner, but just a run-of-the-mill murder case, and convert that into a life without parole situation?
The best way to respond to that, Representative Hatfield, is the way the bill is structured. It will not be, even if there was a prosecutor that you believe were stretching into that circumstance, it's the judge that makes the decision. And the prosecutor would be able to argue to the judge what he or she felt was the appropriate punishment. And if they were overreaching, using your hypothetical, you have the additional filter of the presiding judge who will be looking at it. Judges currently are confronted every single day in criminal court with hearing from both sides and deciding, in every other case but murder, what's the appropriate range of punishment to impose, given what the legislature has said the range is. Judges every day are asked to decide, is this an armed robbery case like Representative Mangum was referring to, that should be a 10-year to serve, or should it be a life sentence for the armed robbery? The prosecutor's role is to give the judge the information that should allow that judge to make the correct decision. So if that circumstance is a concern, I think the system embraces and addresses that.
Okay. Thank you.
Thank you.
Thank you, Mr. McDade.
Thank you, Mr. Chairman.
Appreciate it. Any other individual like to be heard on this bill who has not already signed up? Mr. Collins, did you have something?
Just a question on it. How many more are signed up to speak?
We're none.
I would like to be make a motion.
I appreciate it, Mr. Collins. What we're going to do is we're going to hold the bill until Wednesday so we can do what's necessary on the effective date and take a look at that, digest it a little more, see what we may want to do on the effective date, Chairman Smith. But we'll come back on Wednesday and wrap it up.
Can I add one thing to that?
Sure.
For the committee's consideration, if under the current schedule that's been proposed by the General Assembly, if the bill is passed during the first 35 days by the end of March, say, and we go ahead and then move to immediately transmit it, then there will be no effective date problem. The effective date problem would only exist if the bill is transmitted to the governor for his signature in June, and he had a time period to consider it past the current effective date of July the 1st. Right. So one easy solution that would keep that portion of the bill intact and in a way that everybody previously agreed to is just simply to make that motion to immediately transmit it whenever it is passed by day 35, and I certainly would be open to that idea. So just something to consider as well.
I appreciate that, and I don't disagree with what you're saying. I think just by virtue of the good dialogue we had today, I'd like to allow for a day or two just in case any interested party has an additional thought, not that it would be determinative of any particular action, but that plus the effective date and so forth. I anticipate coming back with a sub on Wednesday morning, and then we can entertain Mr. Collins's motion
I'm not
directly.
Trying to influence your timetable. Just
no.
On the effective date issue, that's something to consider.
I appreciate that. Thank you, sir. Anything else from any member of the committee? With that, we're adjourned. We'll meet again on Wednesday morning at 8:30. Thank you very much.